Good evening and welcome to the LSE and welcome to the Modern Law Review's Chorley Lecture 2019. As many of you know, the Chorley Lecture was inaugurated in honour of our founder, the MLR's founder and first general editor, Theodore Chorley, Lord Chorley. The first Chorley was given by HLA Hart in 1972. Now, before I introduce our speaker for this evening, I just wanted to remind everyone of a somewhat archaic, if I think sociable, MLR tradition, which is that we don't take questions after the lecture. Instead, we go and have a drink and we talk about the lecture, which I think is much better. I hope all of you will be able to join us for a drink after the lecture. Now, tonight, it's a great honour for me to invite Professor West to deliver the 48th Chorley Lecture. Professor West is the Frederick J. Haas Professor of Law and Philosophy at Georgetown Law at the University of Georgetown. Many of you, of course, know Robin and her work very well. I think there are few contemporary scholars who have had such a profound impact on their disciplines as Professor West has had upon hers. Her contributions to the fields of feminist legal theory, constitutional law and theory, jurisprudence, they are truly immense. She's a prolific author. She's the author of 7, almost 8 sole-authored monographs, and the author of 90 journal articles. Yes, that's 8 and 90, and yes, I did count them pretty much all, and in the process of counting them, realized that I have to work a lot harder. And of course, not only is she prolific, but many of those books and those articles are part of the contemporary canon of feminist legal theory and of constitutional legal theory. Think of jurisprudence and gender. Think of the difference in women's hedonistic lives. Think of progressive and conservative constitutionalism. They really are part of the modern canon of feminist and constitutional theory. And tonight, Professor West is going to be talking to us about consent, legitimation, and dysphoria. So please join with me in welcoming Professor West to give the Chorley Lecture.
Thank you so much for that lovely introduction, and thank you so much for attending and for inviting me to deliver this lecture. It's a great honor. It is now a truism that many of the legal obligations of individuals in Western legal systems have moved decisively from status to contract over the last 200 years, by which is meant generally that while an individual's rights and responsibilities were once a function of his or her status, stemming from the circumstances of birth or family position, her status as slave, servant, master, husband, wife, firstborn, later-born, daughter, son. Today, the rights and responsibilities an individual possesses are largely a function of to what he or she has contractually agreed to do or refrain from doing. We contract into our rights and responsibilities. We are not legally assigned them by virtue of the accidents of our birth. Let's see if I can make this work. 1 second here. Okay, start. Albeit less noted, a parallel development in legal consciousness has accompanied this profound doctrinal shift from status to contract, so famously heralded by Henry Maine in the middle of the 19th century, but so prominent a feature of 20th and 21st century legal development. As status has given way to contract, as Maine both observed and predicted, so the power of the law that once created those statuses has steadily given way to that of individual acts of consent that generate, at least in theory, all of those contractual obligations. And as law gives way to consent as the generative source of our rights and responsibilities, so the felt moral authority of law gives way, in turn, to the felt moral authority of consent, thus the shift in consciousness. Today, it is an individual's proffer of consent, rather than any democratically elected law, which we tend to believe deserves respect. Consent, rather than law, in effect, is now the main source of legitimate authority. We can see the shift away from the authority of law and to the authority of consent in large swaths of social and legal life, but nowhere, I believe, is this quasi-Manian shift from law to consent as the necessary and sufficient grounds of the legitimacy of our social roles and responsibilities more vividly manifested than in the mid to late 20th century's twinned feminist movements spanning a number of areas of law for women's civil rights to reproductive and sexual autonomy. These reproductive and sexual civil rights, unlike other United Statesian 20th century civil rights, were decidedly not won either through expansive readings of the anti-discrimination norm, creative interpretations of the constitutional ideal of either substantive or formal equality, expansions of the 14th Amendment's mandate of equal protection of the laws, or through statutory innovations guaranteeing equal participation in, access to, or enjoyment of some aspect of social life. They were rather won through legislative, constitutional, or litigative achievements that rested heavily and sometimes entirely on the quasi-Manian claim that to be recognized as fully human requires that one have the power to consent to one's legal rights and responsibilities in intimate and family life, no less than in public life. Thus, the movement from the authority of law to the authority of consent is not only a foundational story of 20th century law, it is also a pillar of contemporary feminism and feminist jurisprudence. The deference, respect, and moral authority we accord the act of consent in these areas of intimate and family life is the subject of my talk today. In the bulk of what follows, I will put forward two reasons, there may be others, we might want to rethink the authority we now accord the primacy of consent in these areas of life, and hence the grounds of these vital and still fragile civil rights. I will make two critical claims. First, I will argue that the authority we accord the act of consent, a phenomenon which I will sometimes call for brevity the ethic of consent, to the creation of our reproductive rights and duties, may legitimate the oppression and subordination of caregivers, those who choose to continue pregnancies to term and then to mother their children. That cost should be reckoned and countered, whether or not it is great enough to offset the tangible gains in liberty for those who can now legally choose to terminate or avoid pregnancies. That reckoning has not happened. Second, the shift from law to consent as a marker of sexual civil rights, reflected in the redefinition of rape law toward a consent-based definition, argued by almost all feminists in rape law scholarship, the focus on affirmative consent as an antidote to sexual assault on college campuses, and the invigorated movement against sexual assault and sexual harassment harbored by the Me Too movement, may induce, as well as legitimate, what I will call a dysphoric alienation of the deciding self from the subjective self, and particularly from the subjective hedonic self, for those many women and girls, and some boys and men likewise, who often or routinely consent to sex when they neither desire, want, welcome, or find it to be physically pleasurable. That alienation from the hedonic self implies further harms, but it is also itself a harm, which I suggest we label hedonic dysphoria. The valorization of an ethic of consent in our various liberal reform movements in the law of rape and sexual assault veils those dysphoric harms and at the extreme renders them oxymoronic. We should at least countenance those harms and seek to counter them, and thus far, again, we have yet to do so. The first section below elaborates the claim that the ethic of consent now dominates the politics and morality of reproductive and sexual rights. The second section has two parts. The first examines the legitimation costs of the ethic of consent in the realm of reproductive rights, and the second looks at some of the costs of that ethic in the realm of sexual rights, with a focus on the possibility of hedonic dysphoria as a pervasive and mostly unexplored harm. The conclusion suggests a different grounding for these rights that appreciates the necessity of consent to the goodness of sexual and reproductive life, but resists the common implication of its sufficiency. So first, the ethic of consent in reproductive and sexual civil rights. Up to the last third of the 20th century, it was not consent, but rather law, and more specifically, the legally generated status of marriage that determined both sexual and reproductive rights and obligations. So start with sex, meaning our sexual roles, rights, and responsibilities. Marital rape exemptions directly implied the legality of non-consensual marital sex, thus underscoring the mandatory nature of female sexual services within marriage. A married woman was obligated by the combined effect of law and status to provide sex. She was not free to choose to do so or not in accordance with her willed powers of consent. Outside marriage, meanwhile, sodomy laws, adultery laws, fornication laws, and the criminality of prostitution criminalized fully consensual sex, whether it was welcome or not. Thus, both the obligatory sex within marriage, regardless of the absence of consent, and the forbidden consensual sex outside marriage were regulated, criminalized, or mandated through laws that attached to legally created statuses rather than according to consent or its absence. It bears emphasis that this was not a 19th century pre-Manian stage of our ancestors' legal history. Rather, consensual sex outside marriage was criminal, and non-consensual sex within marriage was legal until well into the 1970s in the States. Thus, until very recently, it was not consent that determined the line between rape and sex, or between legal and illegal sex, either inside or outside marriage. It was marriage and marital status that determined the legality of sex and the responsibility to provide or withhold it. The same was true broadly of reproduction. By virtue of the legality of marital rape and the illegality of both contraception and abortion, 19th and 20th century American law, again until the 1970s, went a long way toward ensuring that intercourse within marriage, whether or not it was consensual, would lead to pregnancies, which would in turn lead to reproduction and maternity. Consent had nothing to do with the progression. Without access to abortion or contraception, repeated penetrative coital sex within marriage will regularly produce a pregnancy followed by a birth, and it will do so with or without a wife's consent to either the sex itself or the pregnancy that results. Reproduction and maternity were thus as mandatory for married women as the sex that led to them. The rights and responsibilities that attached to pregnancy and maternity, both in no way hinged on her consent. Outside marriage, the law discouraged extramarital reproduction, and again, the unmarried woman's consent to or desire for the pregnancy had nothing to do with it. The sex that occasioned the pregnancy was a crime, and stigma and financial penalties were visited upon those who bore the status of illegitimacy. Putting these together, marriage, not consent, was the demarcation of the morality or legality of a pregnancy and the maternity that would follow, no less than of the sex that brought it on. Pregnancy within marriage, effectively mandatory, no matter how non-consensual. Pregnancy outside of marriage, stigmatized, regardless of how much the pregnancy and the baby were wanted. The marital status, rather than consent or welcomeness or any act of will or any subjective state of desire, dictated the legitimacy of the pregnancies that women either endured or enjoyed. Neither pleasure, desire, willfulness, voluntariness, nor consent had anything to do with it. So this legal regime, the set of laws and practices rendering sex, pregnancies, and childbirth mandatory within marriage regardless of the absence of consent, and forbidden or stigmatized outside marriage regardless of the presence of consent, gave way through the last quarter of the 20th century and the first 2 decades of this one to a regime of both maternity and sexuality premised largely upon consent rather than marital status. Again, start with sex. Rape reform movements that targeted marital rape exemptions, spearheaded by feminists, effectively reversed the marital regime with respect to mandatory sex within marriage, while various sexual liberation reforms, some of them led by feminists and some not, effectively reversed or nullified the criminalization of consensual sex outside it. So what connected these two movements, the movement to criminalize the non-consensual sex, the movement to criminalize non-consensual sex within marriage and the movement to decriminalize the consensual sex outside of marriage, was the centrality of consent to the reform vision of both regimes. The very general idea that consent, rather than marriage, should be the demarcation of legal from illegal sex. There was no Brown v. Board of Education, no Supreme Court-led jurisprudential and political and moral shift that triggered or even celebrated this revolution after the fact. But there was nevertheless a momentous political and moral shift. Within marriage, a centuries-long regime of mandatory sex imposed upon wives by willful husbands, coupled with the criminalization of consensual sex outside marriage, gave way to rape laws that criminalized sex not on the basis of marital status, but rather on the basis of consent. Both inside and outside marriage, the legality of sex now depends largely, not entirely, upon whether or not both parties consented, rather than whether or not the sexual partners were married. Likewise, with respect to pregnancy and maternity, with abortion largely decriminalized and birth control widely available, and with maternity outside of marriage destigmatized, it is no longer a pregnant woman's marital status, but rather the presence or absence of her consent that dictates when and whether she conceives, the consequences of any pregnancy, and the onset of motherhood, and this is true whether she becomes pregnant within marriage or outside of it. precisely because, in the states, of the combined effect of Griswold v. Connecticut and Roe v. Wade. In the U.S., a woman does not any longer simply submit to a complex marital, sexual, and reproductive legal regime which imposes a condition of pregnancy and a status of mother upon her within marriage, all of which is then forbidden her outside of marriage. Rather, she wills it into being, whether she's married or not. Pregnancies are either intentional, or they are avoidable through birth control, or they can be legally terminated through abortion. In this sense, pregnancies are now, post-Roe and post-Griswold, broadly consensual. Thus, even after she is pregnant, a woman decides whether or not to remain pregnant and become a mother, and she does so whether or not she's married. She's as free not to be a mother if she so decides within marriage, as she is free to become a mother if physically possible and if she decides to do so outside of marriage. So both depend upon her consent and not her marital status. Neither choice is anywhere nearly as legally constrained or determined as it once was. I'm going to call the legal regime of which this is the consequence consensual maternity. So if we put this together with the parallel revolution in the way we now think of sexual life, sex is legal not so long as it is marital, but rather so long as it is consensual, we can reach some broad conclusions. For a married woman at mid-20th century, sex, conception, pregnancy, childbirth, and motherhood were mandatory. Her lack of consent was irrelevant to her non-waivable duty to engage in sex, conceive, carry the pregnancy to term, give birth, and then to mother. For a woman outside marriage, the mirrored opposite was true. Sex, conception, pregnancy, and motherhood were all either criminalized or disincentivized, and all regardless of her consent or desire. Marriage, status, and law were the determinants of reproductive and sexual life and behavior both, not consent. Today, that's all been flipped. Neither reproductive nor sexual duties and responsibilities turn on status, and indeed to argue that they should is widely regarded as advocating the imposition upon women of a regime akin to slavery. Taken collectively, this constitutes a striking and pervasive movement from law to consent. The magnetism of consent has pulled within its orbit virtually all of the familial, sexual, and reproductive rights attached to gender, which were once unambiguously a function of law and status, and which are now also unambiguously regarded as hard-fought and newly won civil rights. So the civil rights for women that have come on the heels of this revolution, and particularly the civil rights to be free of assault of sex and mandatory maternity, but also the civil rights to engage in consensual sex and maternity outside of marriage, have not been a consequence of a wider or more expansive reading of anti-discrimination law, nor have they been won through adherence to any conception of equality. Neither Title VII, nor the anti-discrimination norm of the 14th Amendment, nor the ideal of formal equality that in some way animates both, were the primary legal tool with which these gains in women's civil rights were secured. Doctrinally, the revolution in women's civil rights around reproductive autonomy came from judicial interpretation of constitutional norms around privacy, and somewhat notoriously, not from anything relating to non-discrimination or equality. The revolution in rights around sexual autonomy inside marriage came primarily from state legislative changes to rape laws, not from courts guided by any interpretation of the 14th Amendment's Equality Clause. The rights to consensual sex and maternity outside of marriage came largely from expansive Supreme Court readings of constitutional principles governing personal liberty. In all of these cases, the legal changes followed political and legal movements that stressed neither anti-discrimination nor formal equality, but rather a woman's rights to the exercise of choice, to the availability of exit, to her capacity to consent, and to physical and moral autonomy. They rested on the overall case for giving to women the choice to become a mother or terminate a pregnancy, of endowing her with the right of sovereignty over her own body and her enjoyment of physical integrity, of recognizing her need for agency in her own life, including sexual agency, of acknowledging a woman's right and capacity to say yes to sex or maternity, as well as her right to say no, and regardless of whether she's married or not, to the woman or the man demanding or asking it. Women's reproductive and sexual civil rights were born and short of the need to be rid of a status-driven, law-defined existence and to enjoy instead a self-willed one with respect to sexuality, reproduction, pregnancy, and motherhood all. Those rights create, confer, and validate women's power to consent or to withhold consent from sex, and to consent or withhold consent to pregnancy and motherhood, rather than have the rights and responsibilities of sexual and maternal labor assigned by status and law. They are in accord with the deepest impulses of the mania narrative, the movement from status to contract as the font of rights and responsibilities, and underlying that shift, the movement away from law and toward consent as the means by which rights and responsibilities come into being. And as such, they bring the promises of liberalism and of liberal legalism at least within reach of women's reproductive and sexual lives, precisely the group of people in the areas of life initially accepted from Maine's historic account of the arc of 19th, 20th century law toward consent and contract. Okay. Let's see how we're doing here. Okay. Okay, so the costs of all that, legitimation costs. Let me now turn to some of the costs of this turn toward consent and away from the law as the font of rights and responsibilities in women's sexual and reproductive lives. According to a sizable body of critical legal scholarship developed in the 70s, 80s, and 90s, our reliance on consent rather than law as the marker of what is legal and what is not, particularly in market-based liberal political structures, has the side effect of legitimating that to which consent has been given as good as well as legal. It cordons off from criticism as well as political change, not only inquiry into the value of the transaction itself, but also the fairness of the social world that motivated it, what I'll sometimes call the upstream conditions, and the overall goodness or utility of the post-consent world it brings into being, what I'll sometimes call the downstream consequences of an act of consent. Thus, in consumer transactions, the consent of the buyer and seller to a trade, according to critical contract scholars, shields the fairness of the world that motivated the trade, as well as the decency or the goodness of the world it brings into being, from any sort of meaningful critique. Likewise, the consent of a laborer to a labor contract, according to critical labor scholars, shields the fairness of the background conditions of the labor relation and the goodness of the new world it creates from moral criticism and therefore from political change. And third, according to both groups of critical scholars, the participants to these labor and commercial transactions regularly overvalue that for which they have traded. In short, consent wrongly confers goodness or value on that to which consent is proffered. This is generally what I take the legitimation critique from the 70s, 80s, and 90s critical legal scholarship to claim. The consent to a labor or a commercial transaction legitimates the background conditions that motivated the consent, the goodness of the world the consensual transaction brings into being, and more generally, the value of that for which consent is tendered. Yet, there is no similar critical scholarship from feminism or elsewhere regarding women's reproductive and sexual rights, precisely the area of civil rights law in which consent looms so large as to cast in shadow other egalitarian civil rights values. This is, if nothing else, anomalous. The divide between legal sex and rape now turns on the presence or absence of consent, no less than does the divide between theft and exchange and between labor and slavery. The rights to reproductive liberty that emanate from Roe and Griswold are also grounded solidly, both in law and in the public mind and the ethic of consent. If anything, the legitimating rhetoric of consent is greater in the reproductive and sexual context than in the context of trade and labor. Given our embrace of LGBTQ rights, our overdue rejection of the stigma of illegitimacy, the sexual revolution writ large, and general endorsement of the broad contours of liberal sex education in public schools, we now laud consensual sex more assertively and with greater confidence than we laud consensual labor. And given Roe and Griswold, we laud consensual pregnancies and lament the non-consensual ones, and the ways we once lauded marital pregnancies and lamented pregnancies outside marriage. The ethic of consent has now so thoroughly supplanted the regime of law in the creation of the rights and responsibilities surrounding sex and pregnancy, I would predict, as to withstand backlash on sexual rights and even the reversal of Roe v. Wade. The sex and the pregnancies we value and valorize will continue to be those triggered by individual acts of will rather than those imposed by the constraints and restraints of the law of marriage. If that's right, then consensual sex and pregnancy, as well as consensual maternity, one might conclude, might likewise carry legitimation costs. Yet there is no body of literature exploring what those costs might be, and this is simply odd. Those costs may be substantial, so I'll try to elucidate two of them. So, the legitimating harms of consensual reproductive rights. Let me begin with the harms that might be legitimated by the ethic of consent as it pertains to pregnancy in the post-Roe and post-Griswold era, and then I'll turn to the harms legitimated or otherwise occasioned by the ethic of consent as it pertains to sex. On pregnancy, there are at least two. First, and as Catherine McKinnon argued 40 years ago, overvaluing a pregnancy because of its consensuality conferred upon it by Roe and Griswold might legitimate the sex that produced the pregnancy, and that might include a lot of non-consensual sex or rape. If pregnancies are regarded as constructively consensual because of the power to terminate them, then non-consensual sex or rape no longer carries the risk of non-consensual pregnancy. And it is, of course, true that a rape does not today carry the risk of a non-consensual pregnancy carried to term, where the pregnancy can be legally terminated. The availability of legal abortion has thus reduced the harmful consequences of rape, thereby to some measure legitimating it. Of course, abortions are costly, morally problematic for many, traumatic for some, and physically difficult experiences for anyone. Nevertheless, the bald fact that an unwanted pregnancy can be terminated carries the unwarranted implication that all pregnancies, including those that result from rape, are consensual and hence relatively harmless. The consensuality of pregnancy implied by the availability of abortion thus reduces the perception of the harmfulness of rape, which is difficult to see in any event. More broadly, and this is the larger concern that prompted McKinnon's critique, not just of Roe v. Wade, but of the pro-choice movement generally, the apparent consensuality of pregnancy, implied by the legality of abortion, can wrongly legitimate not just the harms of rape, but also the harms of coerced sex that can result in pregnancies, where the coercion falls shy of the degree of force necessary to vitiate consent. And much of the sex in which women engage is the result of coercive pressure. The wrongness of consensual but coerced sex, particularly outside marriage, was long attributed largely to the burdens of a non-consensual pregnancy that might follow. With abortion legal and pregnancies that are not terminated, thus presumptively consensual, coercive sex no longer carries a risk of non-consensual pregnancies. As is true of pregnancies caused by rape, the wrongness of consensual but coerced sex is mitigated by the availability of legal abortion should an unwanted pregnancy ensue. Unlike rape, however, the wrongness of consensual but broadly coercive sex is not only hard for many to see, it is flatly denied across any number of cultural lines and for a host of reasons, which I'll explore below. The consensuality of the pregnancies that follow coercive sex, however, given the availability of abortion, is one such reason. So putting these points together, Roe, Griswold, and the regime of consensual reproduction they ushered in diminished the wrongness of the assault of a coercive sex that often precedes and causes it. If non-consensual pregnancy carried to term is no longer a mandatory consequence of coerced sex, then there's that much less reason for a woman or girl to resist coercive sex, that much less reason for a man to refrain from imposing it, that much less reason likewise to societally discourage its occurrence. Coerced, unwanted, unpleasurable, undesired, and unwelcome, albeit consensual sex, becomes at worst simply a bad transactional experience rather than a calamitous, life-changing event. It occasions bad sex and the discomfort and the expense of an abortion, but no long-lasting harm. The harms of the sex, as well as the harm that may be directly consequent to the abortion itself, are thus obscured. Again, the above critique, which I'm recharacterizing as a legitimation critique, was first put forward in McKinnon's early writing on Roe, Griswold, the pro-choice movement, and liberal feminism across the board. There is, however, an additional legitimation cost of the ethic of consent in the context of reproduction, which she did not recognize at all, and which has gone largely unnoticed in the post-Roe and Griswold era. The consensuality of the pregnancies that precede maternity, given the reproductive rights created by Roe and Griswold, legitimates the paucity of rights that attach to the caregiving that follows a birth for those consensual pregnancies that are carried to term. Heterosexually active women have civil and even constitutionally protected rights to contraception with which they can avoid maternity, and pregnant women still have rights to abortion services to do likewise. Caregiving women, however, who bring a pregnancy to term, whether they wanted the pregnancy or not, have virtually no rights that attach by virtue of caregiving labor and from the moment of pregnancy forward. A pregnant woman has a constitutional right to terminate the pregnancy, but she has no rights to assistance with the financial, medical, physical, and emotional costs of the pregnancy, should she decide to carry the pregnancy to term, from either her sexual partner, her community, or the state. There is no such thing as preglimony, as Sherry Motro now calls it. Nor does she have rights to assistance with the costs of the childbirth. This rightlessness regarding the pregnancy bleeds over into a lack of rights postpartum, particularly vis-a-vis the state. A new mother has no constitutional or civil right to assistance when she is fully incapacitated from employment by virtue of the aftermath of childbirth and lactation, and she likewise has no constitutional or civil right to longer-term assistance when her caregiving labor compromises her capacity to engage in market-based labor for compensation during the years of maternity following a birth. No constitutional or civil right to assistance follows from a recognition of the value of caregiving, combined with a recognition of the vulnerability to which caregiving leads. This is a part of a larger phenomenon that I've addressed elsewhere. Caregivers in the U.S. of both sexes, of all genders, whether the object of the caregiving is a newborn, a child, an elder, or a disabled dependent, are bereft of rights. Some caregivers enjoy a highly circumscribed, uncompensated legal right under the Family and Medical Leave Act to not lose a job for 3 months if the caregiver has the right kind of job and a bunch of additional requirements are met. Those rights, however, are grounded not in a recognition of the value of caregiving, but in a worry that a woman's caregiving will lead to stereotypical beliefs that will in turn trigger discrimination in the workplace. Likewise, some caregivers have limited statutory rights to state assistance toward the cost of food and shelter for their dependents, but those rights, again, are heavily circumscribed, grounded not in a recognition of the value of caregiving, but in a recognition of the needs of dependent infants. And it's worth stressing, there's no recognized civil or constitutional right to any of that assistance. FMLA, Family and Medical Leave Act, could be reversed tomorrow with no infringement of anyone's constitutional or civil rights. Aid to mothers or parents or families with infant children is a set of fragile entitlements parceled out according to changing political whims, which could drop to zero with no infringement of anyone's rights. Caregivers, qua caregivers, simply do not enjoy any kind of a right to community support that is both resilient against political change and which stems from the recognized value of the caregiving labor itself. When maternal caregiving was mandatorily tied to marriage, when pregnancies were valorized within marriage regardless of consent rather than the other way around, there was a brutal logic to this paucity of rights. The support for the caregiver presumptively came from the husband, who had both the power to mandate it and a duty to support it. Those presumptions wither away under a legal regime structured by the ethic of consent rather than the ethic of marriage, and that fact was not lost on the armies of women who opposed the ERA in the 1970s. So with maternal caregiving, the consequence of consensual pregnancy, a freely willed result of a consensual transaction, rather than an unwilled consequence of marital status, and widely viewed as such, the woman who engages in it is participating in a form of individualized self-actualization previously denied her. She is also doing so, however, from a posture and in circumstances where thriving and even surviving without considerable support from somewhere, a spouse, partner, community, extended family, a state, is flatly impossible. One cannot support oneself or fulfill one's own needs, much less the needs of dependents, while giving birth, breastfeeding, or tending the needs of babies, infants, toddlers, and preschoolers without assistance, and a lot of it. The demands of caregiving to human infants are inconsistent with the conception of humanity that undergirds liberal assumptions of individualized independence and the rights that attach to that understanding. Without rights, the woman or the man engaged in caregiving work is thus in a position of requiring assistance according to the will of unencumbered co-citizens rather than of possessing an entitlement to assistance by right. The movement from marital status to consent as the framework within which reproductive life is structured did not cause that and may not even have exacerbated that rightlessness, but it has, I believe, legitimated it. It is just that rightlessness and the harms consequent to it, most legitimated by our valorization of consensual ethics in reproductive life. The incompatibility of caregiving with the understanding of individualism at the heart of liberalism and at the heart of consensual ethics is familiar to some forms of feminism and indeed to an array of liberalism's non-feminist critics as well, including some communitarians, some Marxists, and some social conservatives. The incompatibility of caregiving with the most prominent liberal theories of the state also predates both liberal individualism and the rise of the ethic of consent. Pioneering and revolutionary women worldwide have struggled against the infantilization and the exclusion from political and economic life that is inherent in unassisted caregiving. It's too long a history to summarize. My point here is only that what the ethic of consent adds to this historical conundrum is twofold. First, by giving women an exit through reliable birth control and legalized abortion, it provides the liberating possibility of refusing the caregiving role. Perhaps caregiving is incompatible with liberalism, but at least I don't have to partake of it. If I enjoy liberalism and the joys of individualism it bestows, I can just say no to maternity. There's no denying the significance of that liberation. What it also adds, however, is a massive dollop of legitimation to the incompatibility itself, as well as to the struggles of women who do voluntarily or otherwise take up maternity. The struggles, difficulties, and for those living on the margins, the sheer impossibility of giving care to infants and other severely incapacitated dependents in the face of the familiar demands of liberal and individualist self-determination are mightily and even viciously legitimated by the gloss of voluntarism, and with not altogether different consequences from the earlier encasement in a sphere of domesticity. To put it pithily, as it was put to me decades ago by a law partner at Morrison Foerster, who objected to pressure on his firm by feminists and fellow travelers to adopt some form of paid maternity leave for his staff and the junior associates, he said, the decision to parent is now just as consensual as the decision to sail around the world, and it should be regarded as such. Both are hugely expensive and consequential decisions that in some measure incapacitate one from market-rewarded labor, but in both cases, those consequences are consensually assumed by the individual making the choice. The community has and should have no role in rejiggering the entailed costs and benefits. In both cases, consent entails a willed acceptance of those costs and risks by a presumptive adult, and in both cases, there's no footing for a realignment. Grounding reproductive rights in an ethic of consent thus legitimates not only the particular harms borne by the women who so consent, but likewise legitimates a regime dominated by liberal and non-liberal ideals, in which the cost, and neoliberal ideals, in which the costs of caregiving are entirely or nearly entirely privatized. Caregiving itself is relegated to the marginal, and the decision to engage in it rendered no more consequential than any other consumer choice or lifestyle, one possible path that may or may not be chosen. It's a choice, and as such, it is not understood as a necessary or essential life activity worthy of support. It is not constructed or protected by rights. It's only minimally and contingently supported by ordinary law. It is not a defining characteristic of a part of our humanity that must or should be included in a civil vision of inclusion. It is central to neither humanity nor identity. Caregiving itself, therefore, as contrasted with an individual's decision to avoid it, cannot and should not ground civil rights, no matter how they're conceived. Rather, it's a choice among others, and while our civil rights might and happily do protect its voluntarism, that's the end of it. Once the choice is made, the ethic of consent takes over. That which is chosen is by definition not that to which civil rights attach, and Roe and Griswold taken jointly confer the choice. So as is true of all choices post-Roe, the choice to mother entails an acceptance of the risks and benefits that flow. Like all such choices, it facilitates and justifies the withdrawal of communal support for the burdens that choice imposes. Consensual reproduction elevates reproductive life from a domain of enforced domestic servitude to a world of individualized consent. The liberatory consequences of that change are clear and clearly historic. The legitimating consequences are not so clear, but they are severe. The move from law to consent in reproductive life legitimates a regime in which impoverishment is not just a predictable, but a fully acceptable consequence of the individual's choice to expend part of her commodifiable life, her human capital, immersed in the work of giving care to dependents. This is immoral and tragic. The centrality and the nature of reproduction requires a liberal rethinking and a reconceptualization of the human experience, not just a rethinking of our commitment to women's equality. Organized feminism, including academic feminism, should be forcing that rethinking. Reproduction, including reproductive choices, cannot be subsumed within a conception of rugged and self-sufficient individualism. We used to understand that individualism, as it was once conceived, steadfastly depended upon a subordinate other to do the work reproduction entails. The ethic of consent in the context of reproduction, in effect, pulled reproduction out of the domain of female subservience and into the domain of individualism. This was liberating, but it also required the impossible. It legitimates the resulting misery within a gauze of consent to that impossibility. Okay, now the legitimating cost of the ethic of consent in sex. So, the evolution evolution away from law and toward the ethic of consent as the foundation of sexual rights and responsibilities can be seen in any number of areas of law, but most clearly in contemporary legal reform movements regarding rape and sexual assault. What was once the reform liberal feminist position on the law of rape, that consent should be the demarcation of legal from illegal sex, rather than some combination of non-marital status, force, and resistance, just consent, is now widely accepted as largely correct, certainly in popular culture and popular understanding, more slowly but seemingly inevitably in law. Requirements of utmost resistance, of force, and of a non-marital connection between a rapist and his victim are being eroded where they still exist at all, leaving a clean definition of rape or sexual assault with gradations as sexual contact without consent. This is a momentous development, widely lauded as a significant gain in women's civil rights. To whatever degree it holds, women and men have considerably more freedom and equality than that should read women and girls have considerably more freedom and equality than they had under traditional and far more restrictive understandings of the nature of rape and its harms. More problematically, however, consent is also increasingly understood as the moral, and not just the legal, demarcation of acceptable or laudable sex on the one hand, from morally unacceptable sex on the other. The shift to consent as both the demarcation of morally unobjectionable sex and the demarcation of what is legal and what is not is reflected broadly in a number of cultural and social trends. It's what we, meaning parents and sex educators, teach our teenage children they should embrace as a central tenet of sexual ethics, as well as dictating what they must do legally before initiating or engaging in a sexual encounter. It's the message of softcore pornography and popular entertainment likewise, where all parties consent, sex is good and to be celebrated, whatever its content. The erotic downside of this valorization of consent is that sexual partners must be careful to ensure that each partner has indeed consented to each other's sexual overtures, and that has costs to pleasure. It can be a buzzkill. The upside, though, is huge. So long as it is consensual sex, whether it's premarital, extramarital, part of a long-term relationship, or casual, whether it's vanilla or sadomasochistic, whether it involves multiple parties or traditional pairings, and of course, regardless of the sexual orientation or gender of the parties, is all basically immune from criticism. And our teachings on the morality of sex squarely reflect that conviction 40 years after H.L.A. Hart said it should. It is the ethic that's reflected in our acceptance of minority sexual and gender orientations, including the celebratory weddings, the parties, the anniversaries, and the rituals that once attended only privileged sexual and gender orientations, with all colors of the rainbow now unambiguously included in the kingdom of sexual acceptability. It is now uniformly consent, rather than either the sex or gender of the partner, or the marital status of either, or the number of parties, or the vanilla or otherwise nature of the sex that determines its value. As in reproductive life, the liberatory implications and the benefits of our embrace of the ethic of consent in sexual life are striking and by now pretty well understood. Basically, women are less subject to the risks of rape when sexual assault is defined as non-consensual sex, rather than defined more restrictively, and all of us, but particularly sexual minorities, are less subject to the risks of legal persecution or cultural condemnation for any and all of our mutually consensual sexual acts, proclivities, tastes, orientations, and identities. But, as in the realm of consensual reproduction, there are less obvious costs of this turn to the ethic of consent that are to date unreckoned. Some consensual sex, insulated from criticism as well as legal regulation, comes with significant risks of harm that are legitimated by the consensuality of the sex that causes them. Some of these harms are not just legitimated, they're rendered nearly incomprehensible, basically viewed as oxymoronic by large swaths of contemporary liberal polity and society both. So, in this section, the remainder of the paper, I want to recharacterize some of the harms of consensual sex that have been obliquely recognized for decades but are now much more explicitly discussed in the literature prompted by the Me Too movement. I then want to discuss in more detail the particular harm I've referenced in the title of this chapter, what I'm calling hedonic dysphoria, which has not to date even been explicitly referenced, much less explored or debated. My aim is to sketch its contours and then to suggest that this is a pervasive type of harm, not just legitimated by, but in some ways caused by, our embrace of the ethic of consent in sexual life. It seems to me it's the harm that's occasioned by our embrace of the ethic of consent in sexual life that is least well understood, least visible, and most in need of criticism. But first, on the more familiar harms. Here, as in the context of reproduction, some of the costs of our turn to consent and away from law is that which demarcates the legal from the illegal in sex can be broadly understood as legitimation costs. They're costs of the aura of legitimacy which consent confers on the background conditions, the downstream consequences, and the underlying value of the transaction occasioned by the act of consent. My basic claim is that all of that legitimated and valorized consensual sex might include a lot of sex that is positively harmful, ought to be regarded as morally problematic, even where it ought not to be legally regulated. Given the ethic of consent, it's harder to suggest that as a possibility. In effect, consent hides the harms of the sex it legitimates behind a veil, just as it hides the harms of consensual pregnancy and maternity, but the harms are very different. So what kinds of potentially harmful sex might be wrongly legitimated by the ethic of consent, and what are the harms consequent to that sex that might be veiled because of it? So a listing, I think, is in order. First and most significant, the category clearly includes coercive sex, where the coercion is not great enough to undercut full autonomy, but not great enough to vitiate consent. Coercive sex, thus defined, produces real harms, and one of the clearest costs of the ethic of consent in the sexual realm is that those harms are legitimated by the ethic of consent. So some examples. Sex for a vague and unstated promise by a partner that he will not employ violence in the future is clearly coercive, but it's also clearly not rape. It's consensual. Does that mean it confers value on both parties? Is it something to applaud? Sex with one's husband or domestic partner in exchange for an expectation that money will be left on the kitchen counter for the kids' school lunches in the morning is broadly coercive, but also it's clearly consensual. The trade is of value to both parties, presumably. Is it therefore a good trade? Exchanges of sex for a placid home life, for a healthier because more pacific environment for oneself and one's children, or for the simple absence of a foul mood from a partner or a spouse the following day might all be coerced, but they're also consensual. They're not assaultive. Likewise, sex given to an undesired but safe man in exchange for his protection against the risk of violent sex that might be threatened by others is coerced, but it's not non-consensual. The critical point here is that the consent that can precede all of this coerced sex in effect legitimates not only the coercive background conditions and the harms implicit in all those background conditions, harms which I assume are self-evident, but also the harms of trading sex to mitigate them, the harms of living in an environment in which one's own desires are not honored, in which one lacks the sovereign power to reserve one's sexual body for uses which will produce one's own pleasures, a world in which sex is a relief from oppression rather than a product of it. So some academic feminists, including, of course, Catherine McKinnon, more recently the philosopher Scott Anderson, have urged, in light of the harms of coerced but consensual sex, that the definition of sexual assault should be widened so as to include coercive sex rather than solely non-consensual sex. For a number of reasons, this position has not taken hold, and the broad feminist consensus on the liberal reform position has remained. The criminality of sex should depend upon the absence of consent, not the presence of coercion. Criminalizing coercive sex would simply sweep too broadly, might also wrongly individualize what are better understood as social ills. The cause of coercion may well be societal or communal or historical and not the predilections or the malignancy of particular perpetrators. I agree with this consensus. One consequence of it, however, is that the harms of coercive sex, sex that is coercive but also consensual and therefore legal, are legitimated. The harms of the sex that is the product of coercion, as well as to some degree the coercive conditions themselves, are shielded from moral critique as well as from legal challenge. It is not, however, only coercive consensual sex, whether that is identified as criminal or not, that is potentially harmful and legitimated by the ethic of consent. Commodified sex is as well. Unwanted, unpleasurable sex that is not consensual and not coerced in any obvious or familiar manner, but which is nevertheless part of a trade, whether the trade is for money or for in-kind necessities, is all largely legitimated by the ethic of consent. Because it is so legitimated, like coerced sex, commodified sex is generally shielded from critique, as are the conditions that prompt the sale and attend it, including not only the poor work and the health protections of sex workers, but also the poor life conditions of women world over who exchange sex for the possibility or promise of life itself. Broadly, the ethic of consent legitimates the harms incident to the commodification of sex and the harms incident to the trades, whether the trades involve the exchange of sex for economic security, affection, status, physical protection, money, promises of various sorts, or other forms of in-kind compensation. It may be unwise for a host of reasons to criminalize sex work. It would, of course, be unwise to criminalize all of these sexual trades. But here, as with coerced sex, note the side effect of the laudable impulse to eschew reliance on criminal law for policing morality. The terms of those trades are insulated from political criticism as well as from legal regulation, as consent legitimates both the practice and its terms. Third, consent legitimates the possible harms of all of the consensual sex worldwide, driven by a sense of duty rather than an expectation of pleasure, whether the duty is compelled by the tenets of a religious faith, by community, by family, or clan expectations. There's little to no discussion in scholarly literature, feminist or otherwise, of the harms that might befall women who, over the course of an entire adult lifetime, regularly submit to heterosex with a man they do not desire, from whom they receive no pleasure, and whom they may not have had a hand in choosing as a life partner because of their subscription to a religious way of life that dictates as much. If the sex in such marriages is not rape because it is broadly consensual, it is, by the dictates of the ethic of consent, not fit for critique, just as sex was once not fit for critique or legal regulation because it was marital. For many women, the ethic of consent is thus doing the work that was once done by marital rape exemptions wherever marriage rests on a religious world order that mandates female sexual submission within marriage to male partners. Fourth, the ethic of consent legitimates the harms of what might best be called hierarchic sex in workplaces or schools that may well be desired and welcomed by both parties, and which is accordingly neither assault nor harassment, but which might be harmful. Sex between workers at a grossly divergent levels in a workplace hierarchy, such as a professor and a graduate student or a president and an intern, is not sexual harassment, so long as it is welcome on all sides, as it was, for example, in the affair between Lewinsky and Clinton. Yet, that sex might blunt workplace ambition when it occurs at work, and it might kill scholarly aspirations when it occurs between professors and students. Such sex is not rape, and it's not harassment, so long as it's welcomed, but it might nevertheless be harmful. We should be discussing those harms, whether we're legally inclined to regulate them or not, and just to be clear, I've elsewhere argued we should not. Fifth, consent legitimates a broad swath of sexual transactions, particularly on college campuses, that might be called culturally mandated, by which I mean sex that is driven by the felt imperatives of a culturally dictated sexual ethic that requires participation in consensual sexual activity as a condition of deeply desired acceptance in a high-status group. Hookups between near strangers on college or high school or middle school campuses that are not desired and not enjoyed and not relished and contain no pleasures for one or both parties, and which are driven not by lust, but by a desire for recognition by a group or by high-status individuals within the group, might carry harms to the health, identity, and integrity of participants. These harms, which over the last 10 years have been the subject of academic study, are beginning to become visible as both campus efforts against sexual assault and the Me Too movement intensify, but they are also somewhat obscured by those movements. Culturally mandated sex, as I'm defining it, is not rape, it's not assault, it's not sexual harassment either, as it can often be welcomed by both parties. Thus, requiring affirmative consent, no matter how defined, rather than simple consent, will not even begin to address the harms of culturally mandated sex on college campuses. This sex is fully consensual. Nor will more vigilant enforcement of sexual harassment laws. I will discuss the harms below, but again, my point here is that the harms of sex consequent to the hookup culture on campuses are insulated from critique and to some degree even from study by the ethic of consent that surrounds them. And they are perversely all the more insulated as efforts intensify to eradicate sexual assault. Worse, those consensual harms are insulated even from recognition by the women and girls and some men and boys who sustain them. Sixth, the ethic of consent shields the possible harms of what some feminists now call maintenance sex, meaning unpleasurable, undesired sex offered in exchange for the maintenance of an emotionally sustaining relationship. Liberal and sex-positive feminists may be right to note that these bargains are often sound, and what is gained, a loving relationship, is often well worth what is lost, which may be minimal. Giving sex to keep a loving relationship intact is, in short, a loving thing to do. The gauze, though, of consent, coupled with the trade's emotional payoff, shields the trades from any sort of critical examination. Is that which is lost truly nothing, and how do we know? The volatility of the issue reveals a lack of certainty, as the vehement discussions around them and defenses of them on blogs quite dramatically demonstrate. So all of this sex, the coerced sex, commodified sex, dutiful sex, hierarchic sex, culturally mandated sex, and maintenance sex, is consensual. All of it might also produce harms that should be named and confronted, and all of those harms, along with the sex itself, are to varying degrees veiled by the legitimating power of the consent that precedes it. Let me make that causal connection before turning to the harms. Start with coercive sex. It's not only liberals and liberal feminists that mask or obscure the harms of coercive sex. As noted above, Catherine McKinnon has long argued that coercion rather than consent should be the demarcation between legal and criminal sex, precisely because so much of what the law regards as consensual is felt by women as coerced, and therefore is felt to be non-consensual, although it's understood by law to be consensual. Note, however, that her conflation does not elucidate the harms of consensual but coerced sex. It erases the category. If all sex that is felt to be coerced is in fact non-consensual, there can hardly be any distinctive harm caused by consensual but coercive sex. We simply don't have a discourse, much less a debate, over either the law's treatment or the ethical status of coerced sex, despite its ubiquity and its self-evident harms. What of commodified sex? Feminists are famously split on the wisdom of legalizing the sex trade, in part because of concerns regarding the labor conditions of sellers, in part because of concerns over utilizing a broken criminal justice system to police against these harms or any others. The debate, however, has rarely addressed the harms of the commodification of sex itself. Rather, it has focused on the apparent lack of autonomy of sex workers. Feminists attuned to the harms of the sex trade characterize participants in it as coerced, and others characterize them as autonomous. More broadly, plenty of feminists, as well as non-feminists, worry that in-kind sexual trades, sex for sustenance, support, food, drugs, a job, status, promotion, high grade in a class, whether between married partners, cohabitors, or strangers, should be subjected to criticism. But here as well, the harms that might be occasioned by this unwelcome sex traded for goods has not been the focus. The focus has instead been on the quasi-coercive nature of the transaction, either because the parties have radically divergent degrees of power, or the woman trading sex for goods is herself so disempowered as to have few other choices. The focus on unequal power here as elsewhere casts the net too broadly. Every sexual exchange, like every non-sexual exchange, involves parties with differing degrees of power, and it casts the wrong net. Sex between parties with different amounts of power is not inherently problematic. It's sex that harms that should be the focus, not sex between differently empowered partners. Sex that is commodified and then given in exchange for non-sexual goods, even if between people with relatively equal power, might be harmful. A focus on the unequal bargaining power of the sex worker and her customer does not elucidate what those harms might be. More quickly, hierarchic sex at work or school has been the subject of political critique and to a lesser degree academic writing for at least 3 decades, but here as well, the debate focuses on whether to characterize that sex as coerced and therefore non-consensual and therefore a form of sexual harassment, rather than on the harms it might occasion, assuming it to be consensual. Similarly, feminists who address maintenance sex, mostly on blogs, and who argue against it typically do so on the grounds that it reflects disempowerment. In all of these cases, the focus is overwhelmingly on whether or not the characterization of the sex as consensual is mistaken, and on whether the woman who gives it is agentic. The felt harms of all of that coercive and hierarchic, commodified, culturally mandated, or duty-driven sex, whether or not the woman is agentic, are rarely delineated. That they are not is in part a function of the embrace of the ethic of consent. So what are the harms? That's my last point. Some of the psychological harms occasioned by the acquiescence and unwanted, we started 5 minutes late, right?
Take time.
Okay. Some of the psychological harms occasioned by the acquiescence in unwanted but consensual sex, what I called above unwanted culturally prescribed sex, particularly among college students, are now being studied, as I mentioned, by a handful of social scientists, more than a handful. It's sort of a cottage industry for PhD theses. Including academic sociologists, social workers, and mental health professionals. The sufferance of at least this form of consensual but unwanted sex, according to a number of recent studies over the last decade, can bring on depression, a feeling of a lack of control, a diminution in felt autonomy and self-regard, and a host of related psychic ills. It also has been shown to correlate with failures to employ birth control, so it heightens the risks of unintentional pregnancies. I've argued elsewhere there may be other harms, not so easily captured, of consensual unwanted sex across the board. A woman or girl who consistently consents to unwelcome sex, whether out of a sense of religious or role-defined duty, subtle coercion, as part of a trade, undermines her own physical integrity as she compromises her body's physical boundaries for reasons unrelated to her own pleasure. There may be psychic violations as well. A woman who engages in unwelcome sex compromises her sense of self-possession. and self-sovereignty as she uses and exposes and gives over her body in a way that is in service to the ends of another rather than to her own ends. And there's a moral harm to her character. She compromises her moral integrity when and if she lies about all this, about her enjoyment of it all later. These harms to physical and psychic and moral integrity can in turn cause what we might think of as political harms. A woman, girl, man, or boy abridges her autonomy when she subjects her body to physical activity toward the end of servicing another. In part because of the Me Too movement, some of the psychological harms and even some of the political harms of consensual but unwanted sex have become the subject of recent blog and journal writing, as well as the subject of debate in the pages of The New Yorker, The Atlantic, and elsewhere. Making a habit of consenting to unwanted sex can lead to habits of self-denigration or political devaluation, which carries its own costs, particularly in a liberal society that not only values, but broadly assumes the pursuit of rational self-interest. A woman or girl in the habit of putting her physical body to the service of the interests, desires, and preferences of another rather than herself might find herself compromised in her ability to use her body and abilities in non-sexual contexts to maximize her own interests and satisfy her own preferences. The habit of self-denigration, in other words, might bleed over. It might not be surprising, for example, that many girls and women, as well as some men and boys, who habitually surrender their bodies for the sexual use of others, might likewise have a difficult time raising their hands in a law school classroom, or negotiating the price of a new car in a favorable direction, or bargaining themselves a wage increase. These political harms, if they exist, are rendered invisible or even oxymoronic by virtue of the legitimating function of the ethic of consent. There's another possible harm, though, that may be more pervasive than either the measurable psychological harms or the speculative political ones that might attend to the sufferance of all the forms of unwanted consensual sex noted above, and that is not only legitimated by the ethic of consent, but is caused by it. A woman, girl, man, or boy who consents to sex she does not welcome, want, or desire, and from which she derives no pleasure, may do so for any number of reasons, as cataloged above, to ward off the danger of future violence from the partner. A mother may do so to ensure the continuing support for her children's needs. A girl or boy, woman or man, may do so to hold at bay a foul mood from a boyfriend or a girlfriend the next day, and of course anyone may do so in exchange for money or in-kind compensation. Many women worldwide consent to sex they don't want because they view it correctly as a part of their marital duty, according to the dictates of their faith. A teenaged girl or boy may do so because of peer pressure or to win the attention of a high-status boy or woman or man. All of that consensual sex might be coercive or commodified or dutiful or peer pressured and so on. What I want to stress here is that most of it is also unwelcome, unwanted, not desired, and not enjoyed. Consent is given without expectation of pleasure, and the expectation is borne out. When that happens, there is, I suggest, a rupture between the phenomenological experience of sexual intimacy and the most basic assumption of the ethic of consent in the context of sex, that consensual transactions are mutually pleasurable and that their value inheres in that fact. That rupture might itself be harmful, and if it is, it's entirely unstudied and largely unnamed. I propose to label the harm that may be caused by the rupture between consensual but unwanted, unpleasurable sex and the social and cultural expectation that consensual sex is mutually beneficial, precisely because it is mutually pleasurable, hedonic sexual dysphoria. By the phrase, I mean to refer to the felt rupture between one's understanding of what is or should be in one's own sexual interest and one's own hedonic experiences of physical pain and pleasure. Hedonic dysphoria, more generally, understood as a rupture between one's hedonic experiences and the expectations defined by the ethic of consent, can occur in realms other than the sexual. It might be most acute, however, in sexual life. In a world in which the ethic of consent holds a firm grip on our understanding of the way we interact with each other and with our natural environment, and in which the law and ethics of sexuality has moved so inexorably toward that ethic, the risk of consensual dysphoria becoming an entrenched feature of our sexual lives, I believe, is high. The harms it might cause are also almost impossible to even assert, much less describe, given the ethic of consent. So to see why, go back to the ethics logic. A consensual transaction, presumptively, brings into being an improved world over the pre-consensual transaction, assuming no negative third-party effects, simply because of its consensuality. The world is richer and more efficient and freer post-consent. Thus, a consensual exchange of money for a product on an open market, a trade to which both parties consent, brings into being a better world than the world prior to the trade by virtue of the mutual consent of the seller and the buyer. The seller has something, money, that he values more than he valued that which he sold, and the buyer likewise has something she values more than the money she relinquished for it. The post-sex world, where both parties have consented, can be modeled on the same understanding. It's presumptively better than the pre-sex world solely by virtue of the presence of consent of both parties. There is, however, a more specific claim intrinsic to the ethic of consent or implied by it. It is not only the world, abstractly considered, that is presumed to be improved by virtue of the consensual trade. More concretely, the individual who renders that consent is presumed to be subjectively happier or more content or more fulfilled or more sated after the consensual act than prior. The maximization of consensual transactions, whether on exchange markets for consumer goods or in intimate life for sexual satisfaction, presumptively contributes to the overall subjective happiness of individuals who are free to engage in them. So what kind of claim is that? It might be definitional, but I think it's typically something more. If the claim that consensual transactions increase subjective happiness is not simply tautological, then it is a general and empirical claim about subjective life. And if so, then it might on occasion not be true. And what happens when it isn't true, particularly where we also believe it to always be true? Well, here's a possibility. When it isn't true, to the degree that the ethic of consent has taken hold as an article of faith about the way the world is constructed, then the result is a divergence or a cleavage between the person's belief that her consent implies that that to which she consented has made her happier or more contented, and her subjective experience of not experiencing any such increase, of being more rather than less miserable after the consensual transaction than before. So the divergence between a belief about one's own subjective experience, I must be happier because I consented to this, and the experience itself, I'm more miserable than I was, is what I call hedonic dysphoria, a jarring experience of a disconnect between one's beliefs about the way one should be experiencing the world and the way one is in fact experiencing it. And that dysphoria can be debilitating. It can also be politically disabling. And it may be pervasive in commercial and work life, but it might be most profound and most damaging and most ubiquitous in sexual life. If it is, then it makes sense to think of or characterize hedonic dysphoria as a direct consequence of the ethic of consent, as well as part of what is broadly legitimated by the ethic of consent and its broad contemporary embrace in sexual life. The ethic of consent teaches that that to which we consent makes us happier and more satisfied and more sated. If that to which we consent instead leaves us frustrated and dissatisfied, and we can't dislodge even in our own minds the ethic of consent as expressive of a true relation between consent and happiness, then we might come to distrust the teaching of our own experiences. When the experience involved is sexual, then the distrust is not just of experience, but the experiences of one's own physical body, and more specifically of one's own hedonic self. The result is a psychic and a physical gaslighting, which is then broadly legitimated by the same ethic of consent which causes it. The gaslighting itself is a part of that to which consent is given, a part of that which is legal by virtue of consent, a part of that which the ethic is not only causing, but as it does so, simultaneously veiling and denying. So to the list of the harms occasioned by consensual sex, legitimated by the consent that precedes it, I would add the possibility of hedonic dysphoria. So how pervasive is it and how harmful? As suggested, women and girls may consent to unpleasurable sex they don't desire or welcome for all sorts of self-serving reasons. They also may consent, however, because they have been repeatedly told and have come to believe that sex is intrinsically pleasurable or desirable so long as it is consensual. And when they do so, they may harbor the belief instilled by round-the-clock advertising, the messaging of soft pornography, depictions of consensual sex in popular entertainment, some forms of liberal sex education, and the sex-positive ethos of high school and college that sex, if consensual, is pleasurable. If it was in fact not, then a woman who experiences as not faces the possibility not just of regret, but of a lack of alignment between the experiences of their physical selves and the social expectation of the nature of that experience. This presumptively pleasurable experience was painful. Anyone in that unenviable position can either begin to challenge the teaching of their culture, peers, religion, community, parents, family, and school, or they deny the teaching of their bodies. So how many girls and women and boys and men do the latter, and what does it entail? Partly it entails denying the significance of one's own pleasures and pains and their connections to preference, choice, and action. Once that happens, It likewise entails breaking the psychic connection which is central to liberal ideology between pain and pleasure on the one hand and preference, choice, and action on the other, where consent is the behavior that effectuates that denial. When engagement is consensual but unpleasurable and undesired sex becomes habitual, then one has entered a habitual state in which one's own pain or pleasure does not direct one's preferences or decisions regarding the use of one's body and access to one's sexual body. One's own pain and pleasure is de minimis in importance. One's own body no longer instructs. It provides no hedonic guidance, much less the kind of natural imperative that Jeremy Bentham once so vigorously insisted upon. In a state of hedonic dysphoria, one does not recoil from pain or feel drawn to pleasure, as he claimed we all do all the time. In a state of sexual hedonic dysphoria, pleasure and pain matter only a little or not at all. At the extreme, hedonic dysphoria entails denying not only the significance, but perhaps the reality of one's own pleasures and pains. Those pleasures or pains just don't exist, we may come to believe, if they don't track the social or cultural script. Can I take 3 minutes for conclusion? Okay. So to sum up, unlike other civil rights, the sexual and reproductive civil rights fought for and won in the last third of the 20th century have been understood almost exclusively in Maine's terms, Henry Maine's terms. What civil rights confer in these areas of life are rights to give or withhold consent, to say no to sex, to abort a pregnancy, to choose not to conceive, to choose not to parent, to decide against maternity. I've argued that while the value of those rights to withhold consent to our lives is great, the ethic of consent which grounds them carries risk. We habitually overvalue the transactions to which we consent. In reproductive and sexual life, as in other areas of life, we wrongly imply from the necessity of consent to both the legality of sex and the obligations of pregnancy that the sex or the pregnancies to which we consent are good. There are costs in that over-evaluation. If we drop the reductive equivalence of sexual and reproductive rights with the ethic of consent, we can imagine or reimagine civil rights in the areas of reproduction and sex both that would better serve the animating purposes of civil rights law as classically understood: inclusion in civil society through the equal protection of ordinary civil laws. What would civil rights thus understood mean in the context of reproduction and sex? A full panoply of reproductive civil rights should include not only rights to birth control and abortion services, not only rights to consent or withhold consent to pregnancy and maternity, but also caregiver rights which would ensure conditions minimal to individual flourishing and civic inclusion when a pregnancy is taken to term. Caregiving is necessary human work. It's of value to the community. It's intensely desired by most people that engage in it. As presently constituted, it carries pervasive risks of impoverishment and isolation, both of which undercut flourishing and civil engagement both. A full understanding of civil rights should include a civil right to give care without risking impoverishment, and therefore a civil right to the legal infrastructure designed to accommodate a full reentrance into public life when the needs of dependents permit it, thus countering the risks of economic impoverishment and isolation that attend to maternity. In sexual life, we might consider positing and then acting on a civil right to be free of unwelcome sex alongside the legal right to be free of non-consensual sex. Such a civil right would be an expansion on one dimension of a civil right we already enjoy, the right we have under sexual harassment law to be free of unwelcome sex in school and work that interferes with a harassed party's right to equal employment or education and therefore with her equality. But unwelcome sex does not happen exclusively or even primarily at work or school, and unwelcome sex outside of work and school is both harmful and ubiquitous. It interferes with a woman's or girl's or boy's or man's physical sovereignty, moral integrity, and autonomy. Indulged over time, it interferes with a woman's flourishing as well as with her psychic capacity and possibly her physical capacity to engage in civic life. We should have a civil right to be free of it. But what might a civil right to be free of unwelcome sex across the board and not just at work, at school, look like? What would be the role of law in its construction? What would law have to do with it? A civil right to be free of unwelcome sex beyond school and work might in some cases be legally enforceable in private lawsuits grounded in tort law against perpetrators. Coercive but consensual sex, for example, could be understood as a civil wrong and one that could give rise to a civil lawsuit. A civil right to be free of unwelcome sex could also mean, though, that we should embrace a moral duty and a political imperative to attend to its causes with an eye toward using law and politics both to eradicate or at least ameliorate the conditions. If so, it would track the logic of legitimation critiques quite broadly. Demonstrations of the legitimation harms intrinsic to the ethic of consent in commercial and labor markets are typically not aimed at curtailing the operation of consent in those markets. They're aimed at illuminating the background conditions that make the trades to which consent is given so coercive, and the same should be true here. So a civil right to be free of unwelcome sex might rest on law only indirectly and require not so much a civil action as a civil education, minimally sex education, that would emphasize the difference between legal sex and good sex, and that would emphasize the reasons, whether stemming from the teachings of high, mid, or lowbrow culture, pornography, religious texts, politically liberatory movements themselves, that have obscured that reality. The lesson is not complicated. For sex to be good, morally and hedonically, it must not only be consensual, it must be wanted and welcomed by both or all parties. I don't see why this could not be a mandatory part of sex education courses. Don't have sex unless both parties want it. That's a simple, but it's a significant change from the familiar liberal bromide, not to have sex unless both parties consent. It might also mean attending to the messaging of pornography, regardless of whether or not we are capable of censoring it, and taking a conscious attempt to counter it where necessary. The message central to so much pornography, that all women and all men desire sex all the time, isn't true. Our current love affair with consensual sex, like our love for consensual maternity, blinds us to these harms. As with the ethic of consent in other parts of our lives, it blinds us to the constructive uses, not only of law and legal discourse, but also of civil rights and of civil rights discourse to address the harms of social life. Thank you.
Robin,
Really, no questions?
that was amazing. Just a brilliant, thought-provoking lecture, and it was just really wonderful just sitting here and listening to your paper. So thank you. Now, I have loads of questions. I know there are loads of questions here, but we are not going to have any questions. But we're going to go straight to have a glass of wine and ask you lots of questions. So everyone downstairs now, and once again, can you thank Professor for those lectures.